Hello, in today's video, we're going to talk a little bit about what happens if your patent application is rejected by the Patent Office. Hi, I'm Jubin Dana with Dana Legal Services, and in today's video, we're going to go over the process of how a patent application is examined and what happens, what are your options after the patent application is rejected. So the process starts off by talking to a patent attorney and having them prepare your application and then filing it. And by the way, we're talking specifically about non-provisional patent applications. Provisional patent applications never get examined. They just sit there for a year, and after 1 year, they expire. So in this context, we're talking specifically about non-provisional patent applications. So you prepare your non-provisional patent application, you file it, you wait anywhere from 12 months to 18 months, and the patent office picks it up and examines it. So an examiner at the patent office will look at your application, look at your claims, and then issue an office action. More often than not, they issue a rejection. They reject your claims, saying that for whatever reason, which they explain, you can't get a patent on this based on your current claims. No worries, that's fine. You can get a rejection and still end up with a patent being granted. It happens to me all the time. It is a very common thing to get a rejection and then later on get a patent, because what the patent office is telling you is the way you wrote your claims are not patentable. Now, you can disagree with them. So going into the discussion of what are your options when your patent application gets rejected, the first thing is you disagree with them and you write a written response telling them why you disagree. I don't recommend that as the first approach or the best approach. The second option is you set up a meeting with the examiner. You talk to the examiner on the phone and you try to understand what it is as the basis for the examiner rejecting your patent application. Then you go back and prepare a response and you submit it. I highly recommend this approach. And of course, the third option is to do nothing and just let your patent go abandoned. Your patent application go abandoned. Any one of those three options are fine as long as you understand the consequences. So if you if you write a response and submit it without talking to the examiner, there's a couple of pros to that in that you haven't spent time talking to the examiner and you just try to put it all in writing. I don't really even see that as a pro, but I'm saying that. The cons are that you put a lot of data and information in your patent application so that later on when you go to enforce it, the defendants in your patent lawsuit will be able to use that information against you. So number one option, write a response, don't talk to the examiner. Number two option is talk to the examiner, then write a response. This does two things, in my opinion, which are very effective. Number one, you get a good understanding as to how the examiner is interpreting things. And then based on that interpretation, how they are going about writing their rejection. Once you understand their interpretation, you then know how to address the rejection and what you need to do to clarify it. And all of that discussion can be had on the phone with the examiner with no written record. Yes, they do provide an interview summary, which is basically a summary of the telephone call, but that 30-minute phone call is summarized in 2 to 3 sentences typically. And that doesn't create any kind of entry in the record of your patent application that could be used against you effectively. It's very hard from 2 to 3 sentences to know all the things that were discussed. And then you write a response which makes the changes to the claim you feel are necessary, and you provide some very, very brief arguments to support that, which are arguments you've already discussed with the examiner, and the less you write, the better, and then you submit that. Most of the time when you do option number two, which is talk to the examiner, write a response, most of the time when you do option number two, you end up with a very successful result. When you do option one, which is not talk to the examiner and just write a response, you typically end up with another rejection, which is called a final rejection. And then, of course, the third option, doing nothing, your patent application goes abandoned, and that's it. That's the end of the process. Now, if you get a second rejection, which the examiners typically label as a final rejection, is that the end of the process? No, that's not the end of the process. Absolutely not. The process can continue and will continue by you filing a response after final, or filing a request for continued examination, or filing an after final consideration pilot, which allows the examiner a little bit more time. And typically they'll call you and interview the case again, which gives you a second chance to talk to the examiner. Any one of these things can happen, and then one in particular will ensure that your application continues and gets another examination, which is the one called a request for continued examination, or as patent attorneys sometimes refer to it, RCE. So a request for continued examination, or RCE, costs money. You pay money to the patent office, and then they pick it up and examine it and go through the process all over again with you. Hopefully by that time, you've really gotten a chance to understand how the examiner is interpreting your claims, what you need to add in as far as features into your claims so that you can get some protection. So in summary, is it the end of the world when you get a rejection in a patent application? Absolutely not. You can continue the examination with the examiner, and your attorney can help you do that. I'm Jubin Dana. If you have any questions, give us a call. We'll be happy to help you explain some things. Here's our contact info. Look forward to talking to you and helping you. Take care.